Syeed v. Bloomberg.
Counsel. Good afternoon. Neil McKillop on behalf of Appellant. I'd like to reserve 3 minutes for rebuttal.
Yes, sir.
Your Honour, the question here is when a non-resident is denied a job in either New York State or New York City by reason of discrimination, where, under this Court's Hoffman test, is the impact of that discrimination?
Are you asking us to overturn Hoffman?
No.
What are you asking for?
What we're asking for is this. I think the question comes down to this. In terms of the question as I posed it there, where is the impact felt? Is it felt either where the job is located, which would be either New York State or New York City, or where the applicant is located? And we would ask that under Hoffman, the answer to that question is the impact is felt where the employment is
What
located.
if it's a virtual job?
Excuse me, Your Honor?
What if it's a virtual job?
Well, I think even if it's a virtual job, it still will have, the employment staff will still have a locus in that it still will be I mean, in this case here, if it were a remote job, if the UN reporter job, quite unlikely, but if it were a remote job, it would nonetheless be a New York City job.
Why?
Because I think for any particular job, it has to, and again, I can't think of every example off the top of my head, and obviously remote work is something that has come to the fore in recent years, but nonetheless, jobs still have, to one extent or another, a physical locus.
Would that be your direct report? What if your direct report is in New Jersey, but the company's virtually working from New Jersey, but the company's in New York? How would you judge the site of the job?
I think you would judge it by, in those circumstances, by the location of the employer. Not it wouldn't be as it were, the immediate report. But ultimately, if you're talking about a wholly virtual job, there has to be at some point a physical location. And I think in that example, it would be the location of the physical location, the primary physical location of the employer.
Going back to Hoffman for just a moment, even that theory, the physical location of the employment, and we can leave virtual out of it for purposes of this question, that would require a slight adjustment to Hoffman to the extent it says that the employment must be in the work. I think they say the work must be in the city. Here, they're not working in the city. In other words, there's a problem in that I think Hoffman looked at it from the perspective of active employees, not prospective employees.
The way I think that the Second Circuit characterized it is that there's a temporal issue. It's a not yet, in that in Hoffman, the job is already somewhere. In that case, the job is already in Atlanta. Here you have a job that has yet to start. Therefore, it's prospective. So that I think the issue would be, if on day one there's discrimination, does that bring it within the ambit? Whereas if the discrimination occurs before the applicant has yet to begin, does that place it beyond the reach?
Why is the impact where, over here?
Oh, excuse me.
It's
My
okay.
apologies, Your Honor.
Why is the impact where the job is located versus where the applicant is located?
Well, I think the...
Or is it both?
I think the problem is this. So what Hoffman sought in terms of formulating its rule was a rule that was easy to apply and didn't lead to arbitrary and inconsistent results. The problem in terms of, if you focus on where the applicant is located, if, for example, the applicant here had interviewed in New York City for the position and been told immediately following the interview, you're not getting the job, In that case, obviously, the location would meet, if that were the test, it would meet the test, whereas if she didn't interview, she wouldn't meet the test. And I don't think that the reach should be determined by something that arbitrary. In terms of where,
And if she, just to follow up on that
Yes.
virtual, if she interviewed virtually,
well, I think the same point would apply, that it shouldn't, the outcome of the case shouldn't depend on such arbitrary
as long as the
distinctions.
interviewer is in New York?
Excuse me, Your Honor?
As long as the interviewer is in New York, is that what you mean?
No, I don't think it would depend on that either. I think it would depend on where the job, the prospective job is located.
So if we think about this, I'm sorry, go ahead.
No.
If we think about this in terms of what New York's interests are, right, what kinds of interests New York has, and I think if we start with one polar extreme, so employer is in a different state, job is in a different state, employee or prospective employee is in a different state, we would say New York's interest in that is minimal or none, I would think. If you took the other polar end, you'd say everything is in New York, you'd say New York's interest is very high. This is a middle case somewhere, right? And we already have Hoffman as a point of reference, which, at least as I read it, says the physical location of the job and person is enough to put us on the end of the spectrum where New York's interest is not enough. Does that imply anything about where New York's interest is in this kind of a case? Thinking again about what are New York's
Yes.
interests, actually.
Well, I think this, if you look at the facts in Hoffman, I think the focus there was more so the location of the employment rather than the location of the individual. And the reason I say that is this. There were a number of striking facts with regard to the individual there, which is that the individual traveled to New York City for quarterly meetings. The individual found out about the decision to terminate while he was sitting on a plane in Atlanta. In relation to the first of those facts in particular, if the location of the individual mattered, then in Hoffman, for example, if Mr. Hoffman had found out about the decision to terminate him or been informed of it while in New York at one of those quarterly meetings, then that, by implication, may have affected the outcome. But I think it's clear from Hoffman that it wouldn't have affected the outcome. It wasn't about where he may have been located at a given point in time. It was the fact that in his case, his employment was located in Atlanta. The court said at most he had pled that there was a tangential connection between his employment and New York. So I think in terms of either New York State or New York City's interest, it is focused on where the job is
So
located.
if I'm understanding your rule, is it that, assuming she is correct, we'll just assume for one moment she's correct on her allegations that the basis for this decision is one that's prohibited by either or both of the statutes. Let's just go with that for one moment. In other words, it's a discriminatory basis for the denial. That but for the discrimination, she would have been working in New York? Is that the way the rule works in your mind? But
Yes.
for the discrimination, the applicant would have been working in New York?
Yes, and that I think in terms of where New York City's or New York State's interests primarily lie, it's in that fact. The
And
fact that
is that the only requirement, that there's a job in New York? Are there other limiting factors here? And does it have to be an actual job? What if someone puts in a resume and says, if there's an opening in New York, I'd like to be considered for it? Give us some guidance on what kind of factors we should look into, or is it enough to just say there's a job opening in New York? That's the litmus test.
I think there has to be a specific job. I mean, there are cases, there are federal cases which distinguish circumstances where there's a denial of a specific job from what are described as unspecified future job prospects or the hope of working in New York down the line.
Do you have to be a creditable candidate for the job? In other words, if there are qualifications, do you have to meet them? And do you have to actually apply? To Judge Singas's question, what are the parameters of what you would say the reach of the statute is?
Well,
So for example, if there is a job opening and there are requirements that are lawful that I don't meet, and I nonetheless apply, is that sufficient, or is there some cabining principle with respect to whether I'm a viable applicant?
well, I think the questions are, I mean, if I understand the question correctly, I think those considerations are ones that arise in every case, as to whether there is actionable discrimination to begin with. I think the question of the reach of the statutes with regard to a non-resident applicant is a separate question, in that if I understand the question correctly, I think the hurdles described there are ones that would have to be surmounted no matter the case, even if it were a resident
So that's where
applicant.
those limits lie, you would say, is in determining whether it's actionable discrimination, aside from the question here.
Yes, I think you would have to make that showing, as you would have to make in any case. And, you know, I think in terms of where you draw the line here, the line is between a specific job, not again, some unspecified prospect down the line. I mean, I think it's the Schreiber case, for example, where somebody is hired in New Jersey and there's an allegation that there was a promise that somewhere down the line the employee would be able to work in New York. That wouldn't be enough.
And to go back to your discussion of New York's interests, where do we look to figure out what the touchstone is? Is it in the legislative history for the two statutes? Is it in its text? Is it elsewhere? Where do you think we find that guidance?
I think it's in the text, Your Honour. I mean, I think, and Mr. Welton is probably going to address this at greater length, but I think that the text is very clear in terms of what the interests are and where they, as it were, I mean, obviously there's the injury to the plaintiff here, but in terms of the wider interests and the wider impact, I think both statutes are very, very clear in terms of the damage to society as a whole, whether in the city or in the state, that results from discrimination. And here would be the keeping out of people who otherwise would work here but for discrimination.
Let me ask you, I know your red light is on, what if any relevance is there for this analysis that post-Hoffman, the city and the state human rights laws have been amended with respect to how we have to construe and interpret those statutes? Do we need to take that into account, or this is just, you say this squarely fits within the way Hoffman perceived the statutes should be interpreted?
Well, what I would say is this, in terms of the amendments to the city statute, where two of the provisions that were cited in Hoffman were transposed to the city charter, I don't think that has a material effect on the court's analysis. Beyond that, in terms of the state statute, the fact that it was amended to incorporate a liberal construction provision, if this were a close call, we would submit that it's not, but if it were a close call, that may make a difference in terms of our client. It won't make a difference going forward because you have liberal construction provisions in both statutes, but our client is only entitled to the benefit of the city provision. To the extent that it's a close call, I think the mandate of that particular provision would require that a close call come out in favour of plaintiff. But I don't think this is a close call. I think that, and to the extent that that would be the case for plaintiff, so be it. I think, though, more broadly speaking, the laws, or at least the construction provisions going forward, are aligned. I don't think it's a close call, but if it were a close call, that's where I think it would come to bear.
Thank you.
Thank you very much.
I think we would normally, I'm sorry, I think we would normally hear from...
Oh, that's fine.
Yes. Mr. Weldon.
Sorry.
That's okay. It'll give you more to do.
Thank you, Your Honor. Sorry, it was unclear from the calendar who was going.
Second. May it please the Court, Cleland Weldon for amici. When they enacted the human rights laws, the legislature and the City Council sought to guarantee equality of opportunity and to eradicate discrimination and its harmful impacts upon the state and the City of New York. To that end, the HRLs expressly prohibit discrimination against any person, regardless of residency, who wants to avail herself of the opportunities that New York has to offer. So, for example, the HRLs ensure that any person who wants to move from New Jersey into the city does not face discrimination, which he's trying to
Can
remedy.
you address this last question that I asked, whether or not the amendments have any relevance to our analysis?
Do you have a particular amendment in mind?
The ones regarding construction of the statutes,
I,
the liberal construction of the statutes.
no, Your Honor, I don't think they make a difference because even the previous version of the liberal construction provision of the state statute required liberal construction in favor of plaintiffs and in favor of the remedial provisions of the statute, and that's going to favor the plaintiff side in this case, regardless of whether you're talking about the version that existed prior to the amendments or the one that's enforced now.
Counsel, you heard some of the back and forth on where the job is and whether it's remote and other factors. How would you craft a rule going forward for this type of case?
The principal rule would be the location of the opportunity that's at issue. And so, for example, if someone is coming into New York and wants to rent an apartment or a hotel room, you would think that the location of the opportunity is where that is. And we think the same rule should apply here. If the physical location of the job that someone is seeking is in New York, then that job opportunity is protected by the statute.
And could it be one opening of several? What if it was 3 openings, 3 different states? Or perhaps it's not determined yet, or if it would be fully remote, how would you apply your rule?
I think it would depend on the particular facts of given cases, but I don't think that's presented here because the way that the Second Circuit certified the question to you is the job is in New York, the opportunity is in New York. Is there an impact in New York from discrimination in respect of that job? And the answer to that is yes, because discrimination with respect to that opportunity impacts the individual with respect to their equality of opportunity. It impacts the state and the city. So that question is...
So it's both? It's impact on the individual and impact on New York?
What Hoffman requires is impact within the state, within the city. And so in the state and the city's view, impact, yes, covers impacts on the state and the city. And that, I think, is clear that is appropriate from the prefatory provisions of the statutes, which say that the statutes are concerned not only with protecting individuals, but with protecting the social fabric.
Why can't the statutes say explicitly what you're saying, as opposed to just saying liberal construction? After Hoffman, couldn't the legislatures have specifically said that it was clear that impact means where the job is located?
They could...
And even dealt with limiting principles with respect to concerns about the proliferation of lawsuits.
They could have, but I think it wasn't necessary because Hoffman makes clear that what's important is not the residence of the plaintiff, but rather the location of the opportunity. The opportunity there was ongoing employment in Atlanta, so there was no impact in New York. It was subsequently interpreted in the Anderson line of cases to say, look, if you're outside New York, but you're trying to get a job in New York, the impact is on that opportunity, and that impact is sufficient
So
to support jurisdiction.
I realize it's not before us, but do you have a view on the remote work question?
Existing precedent, I think, would say that the location of the actual work is what matters.
Well, if it's remote, how do we determine what the location of the actual work is? If there is a, corporate headquarters in New York with remote work and therefore the location of the employee, the physical location doesn't matter, is that enough? Would you tie it to where the employee happens to reside, even if that's not a requirement for the job itself?
In general, it would be the location of the actual work. I think that there could be difficult gray area edge cases that might require adjudication based on the individual facts of those cases, but that's just the way that the law normally develops. And again, as you said, that's not the question presented here, because what's stipulated is the job is in New York.
Understood. Thank you.
Counsel, I think there's a plausible reading of Hoffman that the impact that they're looking for is would be felt in New York. This is not the facts of Hoffman, but they speak to it in dicta right after the holding. The impact would be felt in New York because that's where the plaintiff works. It seems to suggest, at least one narrow reading of it would be, that the impact has to run through the employee or maybe even the prospective employee, but not through the job. And I think I heard you say, you were talking about impacts to the community, and that doesn't seem to me to come via the plaintiff, but rather some more generalized harm that's being done in the community. Is that an accurate assessment of what you argued, or is this all really tethered to the plaintiff?
It's both, Your Honor. What Hoffman says is you have to have an impact within the state and the city, and that impact can be both on the individual here through the loss of the job opportunity, and it's also on the state and the city themselves from the damage to the social fabric that discrimination does, from the loss of the contributions that this individual could have made to the
Does
city.
Hoffman specifically
Yeah.
say that?
Is that harm contemplated in same question?
It's not stated specifically in Hoffman, no, but that's the way we read the statute. The same language that Hoffman relies on, talking about individuals in the city, inhabitants within the city, that language appears in the prefatory provisions that say both individuals within the city and also we're concerned about harm to the social fabric.
Is it the harm to the individual applicant, or is it also harm, and maybe this is what you mean by the fabric, but tell me, one could argue that there is harm where the job market is one in which there is discrimination afoot, so that if I have a job opening and I am reviewing applicants in a discriminatory way, that effectuates some harm in the local job market. What do you mean by fabric?
So I think that's exactly right in the employment context. I was speaking more broadly because we're also concerned about impacts on housing markets, impacts on public accommodation markets, impacts in education. There's all kinds of things that discrimination can
Is that a
impact.
compensatory injury to an individual plaintiff under the human rights law?
No, an individual plaintiff would have to show their own damages, but that's a damages question. What we're talking about here, the Hoffman question, is about subject matter jurisdiction, whether they can get into court in the first place.
And if the harm is to the community or the job market in New York, leaving aside the direct impact on the employee and/or applicant, is it your contention that that's a provable form of injury for an individual plaintiff?
I think injury in terms of damages, or,
Yeah.
I think that would not be a form of provable damages, but again, we're talking about the threshold question of subject matter jurisdiction, which can be invoked based on the harm to the state and the city, because
And
the
could-
state and the city are,
Go ahead, I'm sorry, finish your
I was going to say that the
thought.
state and the city have strong interest in preventing discrimination and preventing those negative impacts on themselves, even if the plaintiff, in order to recover, needs to prove his own damages.
Well, consistent with that obligation, couldn't you bring an enforcement action as the AG against Bloomberg?
Potentially, we could. I think that is a concern with the principle that my friends on the other side, on the Bloomberg side, are saying, because a rule under which there's no impact from this kind of discrimination against the plaintiff would potentially cause problems for enforcement actions going forward if there's no individual within New York that would be able to show an impact.
The way you've articulated the interest, not as to the individual, but as to, let's say, the community or society generally, at least implies an argument maybe that Hoffman was wrongly decided, and let me explain why I'm saying that. I'm sort of thinking in reference to the Foreign Corrupt Practices Act, where companies that register here, even regardless of where they're domiciled or incorporated, are liable for acts of corruption around the world. And so you could say that at least as to a company like Parade, which was a New York corporation, there's a societal interest, a New York interest, in preventing corporations that are headquartered here, certainly, and incorporated here, from discriminating wherever the job happens to be. We didn't hold that. How does that impact, if at all, the way we should think about the interest?
Well, just preliminarily, I think that's a reasonable reading of the statute. 3 judges would have gone with essentially that reading. But you don't need to reach that question here because what's presented are very different facts. In Hoffman, I see my letters on my,
Yeah, please.
in Hoffman, the ongoing opportunity was in Atlanta, and so the injury, the impact were in Atlanta. Here, in this case, the opportunity is in New York, and so the impact on the plaintiff is in New York, even if she doesn't happen to reside or work here yet. And so we don't need to get to the question of whether Hoffman is rightly or wrongly decided. We think that it's on the books, and no one's asked for it to be overruled. But under the rule in Hoffman, in our view, the certified question should be answered in the affirmative.
Thank you.
Thank you. No further questions. Thank you all.
Good afternoon. My name is Elise Bloom, and I'm here representing Bloomberg. This court should answer the certified question in the negative, and I wanted to just begin by responding to some of the questions that had already been asked today. I mean, I think the beauty of the Hoffman test is that, one, it's true to the language of both the state and the city human rights law. And it's also been a test that's been very easy for courts to apply. For example, I know there was a question about remote work. Well, that actually came up in a case post-Hoffman. It came up in the Benham case, where you had an employee who was working remotely from Kentucky for a New York employer. And under the Hoffman test, the impact by that individual was felt in Kentucky, and therefore she did not have a claim under the state or city human rights law.
So can I ask you, if you have two applicants for a job,
Yep.
one is out of state and one is in state, and the employer engages in discriminatory conduct, I take it your position is that the in-state applicant can bring an action, but the out-of-state applicant cannot, where the job is in New York, it's not remote, is that right?
That is my position, and I believe that that position, though, is expressly supported by the language of the city law, which goes to great lengths to focus on the inhabitants, and the state law. And in fact, you know, the state law
What
has-
about the fact that but for, under that hypothetical, but for the discrimination, one could argue that and let's assume the applicant is duly qualified, right? But for the discrimination, the applicant would in fact be working in New York City.
I think that you have to go back to the language of the statute. What are the interests of New York? What interest is New York trying to protect? And under the plain language of the statute, and of course, like no statute is going to be perfect, but under the plain language of the statute, the human rights law is supposed to protect those that either live here or those that work here. And yes, I do think you would have you potentially have someone who would have a claim in New York and somebody who potentially has a claim under a statute in the state where they live.
Let me take your interpretation out as far as I can possibly get it. Bloomberg posts a job application that says, if you are a non-resident of New York State and you are South Asian, you cannot apply for this job. Your reading of the statutes is that's okay.
No, my reading of the human rights law
Yes.
says that for...
State and federal.
State and city.
I'm sorry, city,
Yeah, that
yes.
the state and city,
Right.
my reading of the state and city law says that somebody in New York could bring a claim under the New York law
Mm-hmm.
that challenged that alleged discrimination.
Even though
but-
that person wasn't suffering that discrimination?
I'm sorry, I don't understand the question.
Sure, sorry. The posting says, if you are let's make it even starker.
Sure, go ahead.
This job is available to anybody who lives in New York, but if you don't live in New York, you must be white. That's what the posting says. Neither the city nor the state human rights laws read on that.
Well, the state or city human rights laws, for purposes of a potential non-resident applicant, wouldn't protect that non-resident applicant. There are provisions that deal with advertisements, and there may be an issue under the advertisement section, but for purposes of the discrimination laws, an
That would be
out-of-state
okay.
applicant would not be covered. And look, the state law has an extraterritorial provision, And the state law is very clear that the extraterritorial provision only goes for residents of New York who are discriminated against outside of the state. So if the state and the city wanted to put a provision in their laws that protected non-residents who neither worked nor lived in the city or state, the legislature knows how to do it.
So I take it your position would be the same with respect to applicants to any educational institution or for housing or anything like that, that there could be discrimination as blatant as the hypothetical the chief judge lays out, and as long as it is confined to non-residents, that would not be actionable under the HRL?
Well, I believe there are specific rules that might apply to educational institutions.
Okay, I'm just noting that because it's included in the HRL, but we could use housing as well.
And with regard to housing, I believe that the state actually had attached one of their enforcement decisions, which was very clear that for issues of public accommodation, they are considered differently than issues of employment discrimination, and that Hoffman, while applicable to issues of employment discrimination, would not be applicable to issues of public accommodation. And that was the Lane Allen case that the state had actually included with their brief.
So if we adopted your rule, you just immunize from suit from non-residents. That's the net effect, correct?
I've immunized non-residents from bringing a claim under the state or city law if they applied for a job here in New York. That's correct.
Isn't that inconsistent with the legislature and the city council's directive that courts liberally construe those statutes?
It's
How do you
actually,
reconcile that?
I actually I don't have to reconcile it. I can cite you right to the language from the city council itself. And remember, Hoffman was post the Restoration Act, but there was a second series of amendments in 2016, none of which touched the coverage provisions, but which focused very much on the substantive provisions and whether or not whether the substantive provisions were broad enough. And when the city council in 2016 was talking about what amendments to make and how to view the statute, the city council's debate on the legislation specifically said, insisting that our local law be interpreted broadly and independently will safeguard New Yorkers. So in terms of the coverage, the city council
Yeah,
was...
but that in part does beg the question of what that means, will safeguard New Yorkers. If you read it the way your adversary suggests, that means New Yorkers benefit from a state, and a city of course, where employers cannot discriminate, including against non-resident applicants. So it doesn't really answer Judge Singas's question, I think.
But that's not what the statute says. I mean, the statute, there's nowhere in the statute that you find a protection.
Well, it also doesn't say non-residents are not covered. So it also doesn't say that.
Both the city law and the state law talk about persons within the state or inhabitants. So I would suggest that they do, that in terms of the coverage provisions, that it is tied to the individual, which is what the Hoffman Court recognized, and that...
Let me ask you this, is it possible, well, let me ask you this, under both the city and the state law, does an employee, let's just say they're in New York, they're a New Yorker, and it's a New York workplace, do they have a claim based on some other discriminatory action? Let's just say they bring some action related to some retaliation or some other action.
You mean something that happened to somebody else?
Yes.
I don't believe that they would have a claim for that, no. I mean, the only way
Let's say they went in and they said, apropos of the chief judge's hypotheticals, that, you know, this is discrimination, I can't believe you're doing this, this is outrageous, I'm going to put it on social media, and they say you're fired. Can they bring an action?
Okay, so that person potentially has a claim for retaliation based on what happened to them, that they brought forward what they perceived was some type of discrimination.
Except under your scenario, as I understand your argument, the action that they have taken against the non-resident has no impact in New York. So how is it a claim that would be covered in New York?
Because
Where's the retaliation if you don't have some underlying, at least an attempt at discrimination?
Well, so the employee that gets terminated is someone who works in New York. And the employee that gets terminated is coming forward and saying, I believe there's discrimination. And in order to have a viable retaliation claim, you just have to come forward with
And
a
then the employer
complaint.
says, according to the Court of Appeals, no, I can do whatever I want to a non-resident. You're fired.
Maybe I'm misunderstanding your hypothetical.
Because what's the protected activity that they're being retaliated for?
Is
If,
it-
if there's no discrimination.
Well, for a retaliation claim, it doesn't, and I'm assuming this is a New York employee?
Yes, no, I made it
Okay.
easy that way.
Yeah, okay, so for a retaliation claim, you just have to have a reasonable belief, I think, under the state and city law.
Where would that reasonable belief be if we declared in Hoffman a non-resident doesn't have an action?
I think it's apples and oranges, because it's, and I'm sorry if I'm not understanding your question.
No, you are. We
but
may not agree, but I get you. understand.
I think it's apples and oranges, because remember, Hoffman talks about what is the impact, who's the aggrieved individual? And here, the aggrieved individual is the person who claims, the New York resident who gets terminated because they come forward and say, I think there's discrimination at work, and their employer's
Would
like,
you agree
forget
with
it.
me if they came forward and said, I don't like the fact that I don't have a window in my office? And the employer said, you're fired. You agree with me there, they have no claim, correct?
I don't know if they'd have no
Because the
claim, but they
employer
wouldn't have
can
a claim
make
under,
that choice not to have windows in their office.
yeah, they wouldn't have a claim for under the discrimination
All I was
laws.
analogizing it to was your position that there is no discrimination that's covered when the employer takes this action against a non-resident.
I believe that under the state and city laws, that for a non-resident, that there wouldn't be coverage unless the person works in New York. And again, like the post-Hoffman cases have not had trouble applying the Hoffman test, because like in one of the cases, there was a non-New York employee, but she came to New York and claimed that she was harassed while in New York. Well, the court there said the harassment piece that took place in New York, she felt the impact in New York.
Can we go
So
back
you're-
for a minute?
I'm sorry. Let me
Sorry,
just,
go ahead.
if I can just follow up on this
Yeah.
one, Judge Halligan, I'm sorry. Let me just, I want to make sure I understand the inverse of that and your position on that. So if it is a New York resident, however, who works for a New Jersey company, would they have a claim under the human rights law? Either one, city or state. Let's say they live in Manhattan,
I believe they would.
even though the employer is outside, because in your view, the employee suffers a harm.
Yeah, exactly. I think Hoffman, and I think that, and what I think is really important about the Hoffman rule is not just that it's true to the language of the statute and to the purpose of the statute, but that it makes sense and can be applied. If you were to adopt, well, first of all, the statutes don't talk about harm to the corporations.
And if it's a Manhattanite who's applying for a job in New Jersey, but they're going to live in Manhattan, and they're discriminated against, for, pick whatever ground you want, but they're clearly discriminated against, let's assume for a moment they're going to make out that claim. Are they covered, in your mind, under the statutes?
I think they might be,
Okay, thank you.
because the impact attaches to the person and where they feel the impact, and the person would feel the impact in New York. I mean, look, Ms. Syeed, she probably had a claim under the DC human rights laws, but elected not to bring it. I'm sorry.
Can we just go back to the language of the statutes for a
Yes.
minute, which is, I think, where you directed our attention. So if you look at the purposes provisions of both statutes, they note that discrimination menaces the institutions and foundation of a free democratic state and threatens the peace, et cetera, and general welfare of the state and its inhabitants. So it seems to me that, trying to reconcile that with your view that under these statutes that you can have the type of blatant discrimination that the chief laid out in his hypothetical, and that is nonetheless not actionable. Isn't there an argument that something like that does exactly what the HRL gets at, and that perhaps there is some interest in getting at the discrimination where it involves a job that is in New York or New York City, depending on the statute? What do you make of those pieces of the purposes provisions?
So I think it's a very good question, and this is what I make of it. If you look at, and I see my time is up, can I finish my answer?
Of course.
Okay. If you actually look at the purposes section, and if you look at when they refer to inhabitants, and if you look at, for both statutes, when they refer to either the welfare of the state or they refer to the city, the welfare of the state and the city is always married with and its inhabitants. So I think it's clear, and then there's other sections that just talk about inhabitants or
So
persons
we
within
only
the
care
state.
about the institutions as they affect our inhabitants, not otherwise,
I believe that it's our
under
inhabitants.
the terms of the statute.
Yes, it's inhabitants plus people who work in New York. Because this is the New York legislature.
Well, that's an important plus. I mean,
Yeah.
you correctly point out that the purpose language refers to protecting inhabitants, but we clearly said in Hoffman that this would protect people who are not residents of New York, but nonetheless work in New York.
Absolutely.
So there's a contradiction there with the specific wording of the purpose language. Wouldn't you agree?
No, because I believe that under the language in the statute, that inhabitants has to be interpreted as people who live or work here.
Okay, and this plaintiff, who doesn't live here, but wanted to work here, and would, I think, based on what you just said, would be covered by the statute but for the discrimination that is alleged to have taken place. Is that type of language contradicted anywhere in the specific wording of the statute? And if it's not, and you can tell me if I'm wrong, but I don't think it is, if it's not, wouldn't that be exactly the sort of broad interpretation that we're commanded to give under the law?
I don't think so. And the reason why I don't think so is because if you look at the amendments that talk about the broad construction, again, they talk about the substantive provisions. They don't talk about who's covered. And in fact, they were very careful to not talk about who is covered. You're talking about here somebody who doesn't live in New York, doesn't work in New York, and the impact that person felt was felt in D.C. If we were to adopt a rule that said that anybody anywhere in the country who sends in a resume for a job in New York, regardless of whether they want, let's say they send in a resume to 12 different states, that person is going to be covered by the New York human rights law?
For a job in New York, is my question.
I don't think they would be. They are a non-resident, and to the extent that they don't get the job in New York, they feel the impact of that decision wherever it is that they are living and working, but which is not New York.
But for the discrimination, I hate to harp on it, they would be working in New York. That's the nature of the complaint that you're going to get, right? Whether or not they can prove it is another question, but they are, in their minds, a resident of New York. The only thing stopping, and an employee in New York, the only thing stopping them from doing it is the discrimination that this statute is prohibiting.
To take that to, I don't agree. I do not believe that that's the purpose of the statute, and I also believe, and I'm sorry, can I?
Of course.
I'm sorry.
Now, if you were to take that hypothetical to its logical extreme, like that person theoretically has a claim in each of the states where they sent a resume to, or anybody that sends a resume into New York potentially has a claim if they don't get a job that they said they applied for here.
Well, they're going to have to do more than say, I sent a resume, I didn't get the job, and therefore I'm discriminated against the city human rights and state human rights law. Granted, of course, at the complaint stage, it's a little bit of a lower threshold than establishing your prima facie case, or if you went beyond that, meeting all the burdens of proof. But it's a little hyperbolic, let me put it that way, to say that just sending a resume anywhere. It's like saying, I sent an email. You got to have some basis for the claim.
What about somebody, a California resident who works for a California employer, who says to their California employer, I want to work remotely in New York, and the employer says no? If you take what I think the state is arguing to its logical conclusion, that person potentially would have a claim under the New York.
Well, let's add a little bit to your hypothetical. We know that that employer, California company, has a vacancy for a job in New York that's physically located in New York, right? And the reason given is you can't have the job because you're Latinx.
I think that person,
Does the New York statute read on that?
I do not think that the New York statute would cover a person who's living and working in California. I think that person probably has a claim under California law, but I do not believe that the plain language of the statute and the intent of the legislature would be to cover that person. And I do believe that if the legislature and the city council felt that there was an ambiguity or that those people should be covered, that in the 40-some odd times that they've done amendments since Hoffman was the law 14 years ago, they would have made that change, because clearly they know how to make changes.
Let me ask you, why does it matter that you might have a claim in 2 jurisdictions? Why does that matter? I'm a New Yorker, I work for a New Jersey company, and they discriminate against me. Just to be clear, is your position that the New Yorker has no New York City claim because they could have brought a claim against the New Jersey company in New Jersey?
No, that's not what I was saying. What I was saying is that the person who lives and works in California, to have a claim under the New York law, you have to either live here or you have to work here, because you have to feel the
Let me ask you
impact
this, if we
here.
disagree with you about this language in the statutes that says you broadly construe those respective laws, if we disagree with you that somehow that doesn't apply to how one would define a claimant, do you lose?
Not necessarily,
Why not?
because I think you'd still have to show that some impact was felt in New York.
But doesn't
And-
that beg the question about how broadly you're reading the statute? So again, assume, I know you don't think we're going to do that, but let's assume,
You might.
phantasmagorically as it may be, that we would disagree with you and we would say these provisions in these statutes require that the word inhabitant be given a very broad meaning, which could mean one who, but for the discrimination, would be an inhabitant.
So under the facts of this particular case, I don't think I lose, because and if you look at the record, I think it's A 22 to 23, you see the sum total of the allegations in the complaint that she made. But what you see there is somebody who lives in D.C., who works in D.C., who claims to have expressed an interest to her supervisor in D.C. about some job in New York, and claims that she applied for a job in New York, which she never says was filled or who filled it. So no, I don't think I lose, because I think there's no impact in New York there.
Thank you.
Thank you.
Your Honours, opposing counsel, I think, over and over again in her argument said that there's no impact on plaintiff here because she neither lives nor works in New York. But that's not the argument made in the brief. In the brief, it's that neither lives nor works nor is physically present in New York. So the idea that the Hoffman test has somehow been easy to apply since the Hoffman case itself, I think, is belied by the contradiction between the brief and the argument. It's also belied by the fact that, for whatever reason, failure to hire and failure to promote cases have not been seen at the state level, but they have been seen at the federal level, and there's a split there. So clearly Hoffman has not been easy to apply. The Second Circuit didn't know how to apply it either. And I think that ultimately the language of the statute doesn't provide an answer. There are gaps there. Again, you could read it very literally, as I think Judge Halligan, you pointed out, such that it's only confined to inhabitants. The district court here confined it to people who either lived in New York or already worked in New York. That was the argument made by respondent there, but respondent here added an added element to it, i.e. physical presence. Now that is the essence of as I think I've set forth in appellant's brief, it's the essence of arbitrariness. And I would say this too, I think, regardless of how this case is decided, I think there are going to be difficult cases in terms of where you draw the line with regard to remote work and remote workers. And I think the danger will be, or the concern will be in such a case that you may have, as it were, a second-class workforce within New York who work remotely. But this is not that case. This is not...
Can we go
Yes.
back to the example that your adversary gave where there's a posting of a job in New York, people from, 48 states apply for it, there's a plethora of resumes, all of those people have a cause of action under your theory? Is there any limitation there, or potentially all of them could have, and then you would work it out in the courts with summary judgment motions, et cetera? Like, what's your position on something like that? Forget remote work. There's an actual job, 48 people apply for it from all over the place. Do all of them have a cause of action?
Well, if you take a posting like that, let's say 48 people, 48 New York residents apply, is it potentially possible that 47 of them would have a claim? I guess in theory it is. I don't think it's any different. I think as a matter of reality, that is unlikely to happen. But I don't think, once it's a New York-based job, I don't think that should matter. And I think that whether it's one out-of-state applicant or 10 or 50, to the extent each of them or each plaintiff who asserts a claim, they still have to prove that they were discriminated against. I think the issue here is that, again, to go to another analogy, if you have a posting that draws a distinction between residents and non-residents and essentially communicates that if you're a resident, the job is going to be, or the decision is going to be made in a non-discriminatory fashion, but if you're a non-resident, it's not. I mean, that's something of, I would suggest, an appalling vista. I don't think, in terms of however you would conceive of the city and the state's interests, I don't think this court could countenance that kind of a scenario.
Thank you.
Thank you very much.